Hello there, Jill. Thanks for coming in today. Supposed to get the ball started. What's your primary reason for coming to see me today?
Well, I just came to begin the process of estate planning just by getting my affairs in order and asking your advice on minimising tax, just because I want the best possible outcome for my family in the future.
Oh, definitely. Well, we can certainly help with that. So I suppose a bit of a summary, would your main priorities be tax-effective estate planning and also ensuring that your assets get passed on to your intended beneficiaries from our previous chats? I'm assuming that's your husband and your children.
Yeah, and also just so they're protected, so they can't be challenged by any of their partners.
Yeah, definitely. Well, we can certainly put some asset protection into your will as well, if that's a priority.
Yeah, that would be great.
Perfect. Well, I suppose to start the process, I'll give you a bit of an outline of what we're going to do today. So, to start with, we can go through a fact find. Now, this looks at your current personal situation, your current financial situation, what your family tree looks like at this stage, what sort of goals you'd like included in your estate planning needs. And if you're happy with all the recommendations and our conversations, what I can do from there is we can get a authority to proceed sign, which generally takes about 2 weeks for myself to prepare the written advice, and I can go and liaise with the relevant solicitors and accountants. Now, do you have a solicitor that you use?
No, I don't actually at the moment.
Okay, well, we actually have an estate planning specialist that we liaise with quite often, so we can definitely pass you their information and get the ball rolling.
That would be awesome. Fantastic.
Perfect. So I suppose to start with, we can go through your goals. So just to confirm once again, the three main goals would be tax minimisation to your beneficiaries, asset protection to provide more certainty moving forward, and also to distribute your assets in line with your wishes in the event of your passing.
Yeah, that's all correct.
Okay, now what we can start with within the fact find is just confirming your personal details. So I've actually got a table that I've pre-drawn up from our previous conversation. So I just like to quickly confirm that all of your details are correct. So we've got your full name, your husband's, children's, all the date of births, and also addresses on file.
Yeah, that all looks about right.
Perfect. Okay, I'll just note that one down. Okay, and are you an Australian citizen as well?
Yes, I am.
Perfect. And culturally Australian too?
Yes.
Perfect. Okay. Now, have you been with your husband your whole life, or have you got other partners in the visa?
Has been my only partner, but he did have one wife before me.
Okay, that's what I was going to get. So I was going to ask if you have any stepchildren or foster children, but that's the case.
Yeah.
Would I be able to grab her details too, please?
Yes. So it's just the one.
Yeah.
That's Hillary Kerr.
Hillary Kerr, perfect. And I'll grab the date of birth a bit later if you happen to know.
I will have to get back to you on that one. Sorry.
Fair enough. We can certainly grab that one later. Okay, so we've got that one. I'll just note that down. Okay, now do you currently have any sort of legal representation in your will at this stage?
No, not at the moment.
Okay.
I would also appreciate if you could recommend someone for that as well.
Yeah, definitely. We can definitely recommend someone to facilitate your wishes in the event of your passing. I suppose as well as that, with the family tree, do you have any extended family members that may want to look at assessing some of your assets in the event of your passing, or family friends or anything like that?
Not really. None of my children currently have partners, and I don't really have any siblings. So.
Okay, so our family tree that we have is quite comprehensive at this stage. There's no additional people in that?
No.
Perfect. Okay, I'll put that one down. Okay, so the two children that you do have, they're both working, I believe?
Yes, my son Bailey is a mechanic,
Okay.
and Walter, my second son, he is a plumber as well.
Oh, okay, so they don't rely on you financially at this stage at all?
No.
Okay.
Not overly.
Yes, it's just interesting to go through that because there's different tax implications if you're financially dependent or non-financially dependent. So when the assessment comes, it's normally the judge decides on a case-by-case situation. So there's no set rules. It's very much the judge is deciding decision on the day, so to speak. So generally, you're financially dependent if you recur on incoming frequent payments to maintain lifestyle. So it sounds like neither one of them would be.
No, I don't think it would be.
Perfect. And would Hillary be dependent on either yourself or Jack as well?
I don't think so.
Okay, I'll just quickly put that one down. Perfect. Okay, so we've now got a good understanding of your current situation and family tree. I believe that you said in our initial conversation that you do have a will. Do you know where that one's located?
I definitely have one. My husband and I completed a basic one a while ago. The public trustee, that was about 15 years ago now though. I haven't looked at it since then and I'm not 100% sure where it is. I know it's at home though.
Okay, so maybe on the filing cabinets or something.
Yes.
Okay, that's okay for now, but I think we should definitely fix it up if it's been that much time. I suppose with your will, if you're not too sure where it is, it may be non-current at this stage.
Yeah, it's probably about 15 years old now, to be honest.
Okay. Well, if you do end up passing away and you don't have a current will or you can't locate it, you may die, which is called intestate, which means there's a government formula on who distributes your assets. So we definitely want to avoid that at all costs because it's quite often a costly and timely process and it just makes a big mess of things too. Okay, so we need to update your will. You said before you're happy to use the recommended solicitor here, or would you like to use the public trustee as part of the facilitation of your will?
I think a solicitor is probably the better option. Yes.
Okay, yeah, exactly. So we'd actually recommend that as well because wills are quite complex documents. The simple do-it-yourself will kits are really no good in the majority of cases, especially when you've got lots of different types of assets here, there, and everywhere, which I'm sure you understand. And with the solicitors, they also specialise in the structuring of the will and the specific wording to make sure your wishes are followed to adopt as well, which is also good. Okay, now with your current will, do you know if you have an executor?
Well, actually, I'm not sure. I'm presuming that it has been done through the public trustee, so I presume you'd be handling it over to them, but that is something I have to check also.
Yeah, definitely. Now, quite a few people do have the public trustee as their executor. Alternatively, you can always get a professional, such as a financial planner or an accountant, to act as your executor, a third party, so they're not involved as a beneficiary at all. Or most people actually get their primary beneficiaries to act as executors, or even family friends who sort of conflicts that may arise. Do you have any sort of preference when it comes to your executor at this stage?
I'm thinking maybe a solicitor is the best option for me at the moment. But
yeah, definitely. And another thing, when you choose a professional to enact your will, time of death things can be a bit traumatic, and even though somebody may have capacity to access grant a probate, at the time they may not sort of be up to it because it's a really emotionally draining time. So if you have that third party that's independent, your will is more than likely to be carried out in line with your wishes too.
Yeah, that's what I'm aiming for.
Well, I'll just record that one down now that you are looking at the solicitor to act as your executor as well. Okay. Now, in the event that you do choose a family member and they're not available, what we always recommend is nominating an alternative executor. So the executor carries out your wishes in line with what you have written down in your will. If your executor is not available or can't do so because of capacity reasons, the alternative can step in and ensure that your will is carried out in line with the goals and objectives reported. So we can definitely recommend an alternative as well. Do you have any sort of preference for that as well?
Maybe just my children, or actually maybe my husband.
Okay, perfect. I'll just record that one down. Okay. And do you have any power of attorneys at the moment?
No, I've actually never thought that that would be necessary, that one. I guess I've never really thought about it because both me and my husband are fine at the moment. Should probably start thinking about that though, because we went through that with when my mother-in-law was ill and we had her power of attorney. So I suppose we should get a look at that one too.
Oh, okay. Was she quite old then when you received the power of attorney?
Yeah, she was.
Okay, yeah. We actually find that most people tend to leave setting up their power of attorney to the last minute, which can be a bit tricky because then the beneficiaries can argue that there's no capacity, so the will's invalid when you update the will and the power of attorney too late. So it's always good to get in early, so to speak, and also if you were, say, involved in an accident, at least you know that you have someone that can look after your financial affairs and your medical affairs legally, because if you don't have power of attorney, that's a no-go. You'll sort of be left in the dark there. When we set up a medical power of attorney, we can actually take it one step further if you'd like and get in touch with your doctor and set up an advanced healthcare directive. That sort of gives you a bit of more control. So, for example, you were in a coma, what would you like done? You can discuss those sorts of issues with your doctor, and we can get that in writing too, if that's something you're after.
Yeah, that would definitely be useful, that one.
Okay, perfect. Well, I've got here that you haven't reviewed your will in some time. Do you know if you've got any sort of specific provisions for testamentary trusts at the moment?
No, I'm not 100% sure, but could you please explain that a bit further?
Yes, I can give you a bit of an outline of what a testamentary trust is. So, a testamentary trust is a trust established prior to your death in the will, and when you die, the will actually enables the testamentary trust. Oh, sorry. And the testamentary trust is a separate legal entity, so it actually holds your assets. It's different ownership structure is the gist of it. So it actually provides a lot of flexibility in the areas of income distribution. So that tax minimization objective, we could probably achieve that through the testamentary trust. The distribution of assets, we can probably also achieve that one through the testamentary trust. And your first one, the third one, what was that one?
The tax minimization?
Yeah, tax minimization. Tax minimization, asset protection, and distribute in line with your will can all be done through the testamentary trust. So we can definitely look at sorting out that as well.
Yeah, would I be able to look at your recommendations regarding that later as well?
Yeah, definitely. Perhaps we can get a bit of a breakdown of your assets and liabilities first to get a better understanding of what sort of assets would be put into the trust and what sort of assets could be held outside the trust. So what would you say your primary asset is at this stage?
I've actually brought a list with me that just shows all my assets and liabilities to make things a bit easier.
Oh, perfect. That's very helpful. I know that many people go to that much detail, which is nice to see. And it looks like you've even got the date you acquired most of the assets too. That's very helpful for any sort of taxes in the future. Okay, so your first one you've listed is your home. Is that currently owned joint with your husband, or do you have sort of separate percentages of who owns the home?
We actually own that one together. Yeah.
Okay, perfect. And do you intend that to go to your husband in the event of you passing, or would you like that to go to the children?
To my husband. Yes.
Perfect. Okay, I will just record that one done. Okay, the next one here is your investment property. Now, is that one also jointly owned with your husband?
Yes, that one is also.
Okay, and would you like that one to go straight to your husband as well, or would you like that to go to the children?
I'd probably prefer that to go to the children, just a bit more set up in the future.
Okay, well, we can definitely look at that one. Now, I must say that it looks like it's a joint tenancy at the moment, so what we can do is we can actually change the asset structure. So with joint tenancy, it goes to the surviving spouse automatically, whereas if we change that to what's called tenants in common, that breaks down the asset ownership. So in the event of your passing, your portion of the house will actually go to your intended beneficiaries rather than the other tenant, if that makes sense. So we can definitely look at changing the ownership structure. There may be stamp duty and capital gains tax incurred. We'll get a bit of a detailed report from the accountant just so you're fully aware before you make any sort of major changes like that.
Yeah, that would be good.
Perfect, that sounds good. Okay. Okay, it looks like your next largest asset is your superannuation. Is that correct?
Yes. I've got probably about 400,000 at the moment in that one.
That's very nice. And do you have any sort of personal insurance inside or outside of super as well?
No, not on that one.
Okay, perfect. The reason I asked super and insurance questions together is they're actually both what we consider non-estate assets, so they don't actually form part of the will. So we've actually got to put separate provisions in place to ensure that the assets are distributed in line with your wishes once again. And there's also different tax implications for superannuation as well, which I can give you a bit of a rundown later too. So with your superannuation, who would you like that distributed to?
I haven't really thought about that one, but I think I would probably leave it to my husband, or if he's not around, definitely my children.
Okay, perfect. Well, have you got any sort of debt nominations in place at the moment that you're aware of?
Oh, I haven't looked at it in years, really.
Okay, fair enough. See, it's one of those things that's in the back of everyone's mind.
Yeah, exactly.
Okay, well, we'll definitely look into that one. There's actually two types of nominations we can look at doing. The first one is a non-binding nomination, which is the standard one most people do when they set up the fund. Non-binding gives the superannuation trustee a bit of an idea of who you'd like your money to go to in the event of you passing, but it's not set in stone, so to speak. So it's only a recommendation. So what that means is quite often I've actually seen cases where the assets don't get distributed properly. So the other option is a binding debt nomination. Now, what this means is that it's more so set in concrete. Your nomination, it's binding on the trustee, so it's a lot more secure. The only thing with that though is that every 3 years it normally lapses. Some specific super funds have non-lapsing, but as is at the moment, most super funds do have that 3-year lapsing rule. So we'll have to look into your super fund on an individual basis and also Jack Super Fund as well. How does that sound?
Yeah, that sounds good. That sounds.
Do you have a preference which one you prefer?
No, not entirely sure at this current stage.
Yeah, definitely. Well, we can always come back to that one if that's an issue. With your superannuation, as I said before, it's a non-estate asset though. So in the event of, say, marriage breakdown, and that's not very likely, but I always let my clients know this. If you change your will and you don't change your super benefits will still more than likely go to who you've nominated, especially if it's binding. Okay.
Yes.
Okay. I'll just note that one down. That you're happy with that.
Also, would you be able to tell me the benefits of a trust again?
Yeah, definitely. I can tell you the benefits of a trust. So, well, the most common types of trust that we recommend in estate planning is called a discretionary testamentary trust. Now, the testamentary trust, as I mentioned, is linked to the will, and the discretionary part gives you more control over the assets. It gives the trustee the discretion to distribute income, which is where that tax effective element comes in to play. There are a number of different trusts available, but that's the one that we focus on as far as the estate planning goes. Once again, it does quarantine those assets into the trust environment. So in the event, say, of your children's future marriage breakdowns, those assets will be segregated from the ones held directly, which means that in divorce proceedings, it is very unlikely that the spouse can actually access those assets, which gives you that level of certainty moving forward that your hard-earned money is not going to go to an ex-partner of your children.
Yeah, that does sound good.
And once again, full distribution is enacted in the trustee as well, so you've got lots of control over the actual asset distribution too. Okay, how does that sound so far?
Yeah, that sounds perfect, really.
Perfect, I'll just write that one down. Okay. Okay, so it looks like we can really achieve those three primary objectives of saving tax, the distribution in line with your wishes, and also the third one, which was the protecting your funds. We've got a really good understanding of your current personal financial details as well as your family tree. We've worked out that both your children and Hillary are non-financial dependents. Now, I will mention, even though it's not really relevant to your case, if you leave the money to Jack from your super, but if you were to decide to leave your superannuation benefits to your children, as you said you may do, Jack is a financial dependent, so he will actually receive the superannuation tax-free in the event of your passing. And similarly with Jack's passing, you receive it tax-free, whereas the two children are non-tax dependents from a superannuation standpoint, especially. They'll actually incur a 17% tax on taking lump sums out, which is 15% plus the 2% Medicare at this stage. So that's a really important consideration if you do decide to nominate your children for that one. Perfect. Okay. So as far as when we do create the discretionary testamentary trust, if that's still something you wish to proceed with, what we'll have to do is create a new will, which we're going to do anyway because was not in line with your objectives at the moment. Appoint a valid executor to your will, so they can distribute your assets in line with what you'd like. Also, put in place that alternative as a bit of a safety net. Agree?
Yeah, that would be good.
And this here, once again, is the checklist for appointing people to power of attorney. Now, we want to make sure that any executors do, in fact, not power of attorney, not all of that, sorry. We do want to ensure that any executors do obtain that grant of probate, so you can distribute your will in line with your wishes. So there is quite strict criteria, so I'd like to have a good think about it, and then get back to me maybe after you call tomorrow and check to see how you and Jack go with that one. Okay, and you're also looking at implementing enduring power of attorney for somebody to act in the event of sickness, or if you can't make financial decisions for yourself, you lose capacity. And also the medical one. Were you interested in doing the Advanced Healthcare Directive as part of that?
Yes, I'll have to get onto my doctor with that one, or will you help with that one?
Yeah, well, I can help with that one. I can liaise with the doctor. I should probably take down the numbers. Maybe you can send that in the email or tomorrow.
Yeah, that sounds good.
Perfect. Okay, so I'll just mention once again that with the will, those non-estate assets, so your superannuation and anything held in joint tenancy, so basically your principal place of residence, won't be included in the will, as they have different laws governing those, but everything else is included in the will. We can actually put your superannuation in your will, and we make a non-binding, death nomination to your estate. Is that something you'd like to consider as well, or would you like it to go straight to Jack?
I think I will consider it, but Jack is, again, always
your first choice.
Yeah.
Okay, so I suppose the process from here, I've got your accountant's details. I can forward you the information of the solicitors that we discussed before. I can send them letters outlining what you're hoping to achieve and your current position. And that way, from the accountants, we can look at what sort of tax implications may occur, and then sort of fees payable from that end. And from the solicitors, we can look at the correct structuring and the appointment of the trustees and power of attorneys and things like that, in line with your wishes. I think that we should probably meet up in, say, 2 weeks' time. That'll probably give me enough time to draft up all the relevant documentation and to liaise with the accountants and solicitors. Do you have any questions in the meantime?
No, I think you've covered everything that I wanted to know today, actually.
Perfect. Okay. And once again, with those solicitors, we really do recommend utilising them because of the specific wording around the structuring of assets and those trusts as well.
Yeah, I'll definitely keep that in mind. I'll probably lean towards going with them.
Fair enough. I suppose most people actually do these days. Okay, so now what I'll get you to do is I'll just get you to sign this form to proceed, which read that one. Perfect. Well, thank you for your time today, Jill. I will be in touch tomorrow, as discussed, and then we can arrange a time, 2 weeks' time, to have a catch up and get Jack there as well.
Awesome. Well, thank you very much for
Thanks
today.
for your time, and have a great evening.
Yeah.